All right. In order to talk about any judge that we do not know personally, all we are left with is their professional record. United, if we're going to talk about Judge Barrett, she's currently a judge with the United States Court of Appeals for the Seventh Circuit. The Seventh Circuit consists of three states: Illinois, Wisconsin, and Indiana. The case that I want to discuss is Illinois Republican Party versus J.B. Pritzker, Governor of Illinois. This is an appeal that was taken from the District Court, appeal from the United States District Court for the Northern District of Illinois, Eastern Division. That This is not an appeal on the entire case. This is an appeal only for a temporary order, which we call as an injunction, to stop the other party from committing an act or to stop the other party from preventing you from doing something. So either to allow you to do something or allow you to stop doing something. Basically, that's all it means. While the case is still going on. So there is no final decision in the district court. Therefore, there cannot be any appeal on the final decision on the merits of the case. So this judge is before Judges Wood, Barrett, and St. Eve. These are the circuit judges. The reason I'm talking about this case is because you brought it up. You brought it to my notice that people are obviously researching Amy Coney Barrett because she is one of the top contenders to replace Justice Ginsburg, correct?
Right.
Yeah, and who in particular? So it seems like a lot of people are bringing this case up, but you mentioned a particular name.
Right. So I've seen, people have seen this around, but in particular, I saw it was on Twitter, attorney Robert Barnes, who's an attorney in Las Vegas, that he's making the case very, trying to make the case a strong case against Barrett as the nominee. And one of the things he likes to cite are his, is her record, her court record, her decisions, particularly in this case and some other ones. And he talks about her being, siding with authoritarianism, not being a true conservative judge, et cetera, et cetera. Basically, we don't want her. She's going to be a sleeper cell judge like John Roberts. She's not going to be. She's not what people think. It's kind of what he's saying, I think.
Got it. Okay. So as far as the authoritarianism, I believe the the person here with authority is Governor J.B. Pritzker, who has issued a series of executive orders designed to limit the virus's opportunities to spread. This is the backdrop is the ongoing COVID-19 coronavirus pandemic. Okay, so at question right now is an executive order of Governor Pritzker called EO 43, Executive Order 43, issued on June 26, 2020. And basically, what it does is prevents people more than 50 to come together for any purpose. Now, he also did carve out an exception to allow places of worship to have more than 50 people. Now, it's not indoors, it allows more than 50 people, that is maybe 100 people, to get together, but it still has to be outdoors. They have to wear masks and take all precautions for the pandemic. The Republican Party says, and I'm going to go over the facts quickly. The Illinois Republican Party says what governor is trying to do is, through his executive order, he's allowing people, if they're praying in the name of Jesus Christ, it is okay to be more than 50. But if we are talking about, say, Donald Trump, then it's not okay. So their contention is that speech, what the church is doing is speech. What we are under undertaking is also speech. However, the executive order punishes us for the content of our speech. If we were praying about some God, it is okay. But if we are praying about our leader, Donald Trump, it's not okay. That's the primary contention. Okay. So in this case, Judge Barrett says, not so fast. And she goes through the history of First Amendment cases. And through their reading, what she has to say is yes, the First Amendment forbids the government from, uh, passing any laws for the free exercise of religion and also thereof of speech, of the press, and the people's right to get together. However, reading through all the cases of the Supreme Court of the land, it is clear that the free exercise clause of religion does include speech, but it includes something more than speech. In other words, it's speech plus. The court literally uses this phrase, speech plus. What the Illinois Republican Party wants to indulge in is speech. What the church wants to indulge in is not just speech, it is speech plus. That is, when you go to church, it's not just talking, it's the ceremony, it's the clothes you wear, it's the walk up to the priest and back, and whatever actions you take, you shake hands, all these things. Like when you go to church, they shake hands maybe and they say, the Lord be with you, or peace be with you, or something like that. I've observed this. Uh, so that is not just
Are
speech.
you, are
Yes, go
you,
ahead.
just a quick question. Are you painting that more clear picture? Did they talk about that in the
They
decision?
they actually
You know,
they
did they try
actually
and
they talk about the all these things. When I but they go at length, right? Nobody has the time to go through the entire analysis. But
Mhm.
so yeah, so the court actually differentiates between this, and in fact, um, the court also says the plaintiff, that is the Illinois Republican Party, is not even saying that you are discriminating us, and therefore they should not be allowed more than 50 people. In fact, it's quite the other way around. They say, oh, yeah, they should be allowed more than 50 people, the church that is, but we should also be allowed. And the court says, no, there is a reason why there is a restriction on First Amendment rights right now. And that really is nothing to do with the content of the speech. It's only to do with the number of people that can come together. It's 50. The and then they also raise a contention that um, what do you say? Uh, the protests that were going on during the pandemic were allowed, and definitely more than 100 people were there at the protest, probably even in several hundreds or even 1,000 people. But we were not allowed to do that, and the governor has put uh, a uh, a boundary on our actions, but the protesters are boundless. And then the court says, well, if you were stopped in a certain city from conducting your speech, you will also have to demonstrate that the governor or his uh, state police stopped you. That's not the case. They failed to demonstrate that either. What they are saying is the local police allowed this and they did not allow us to do it. Now the court does not get into this analysis, so this is my analysis. I think this case is just a botched attempt at making these judges do what the Republican Party of Illinois wants. I think politically, how they're looking at it is these three judges out of these three judges, two of them are Reagan appointees. One is a Trump appointee. So they're all so-called Republican judges. We are the Illinois Republican Party. So we can take any prayer there and they're going to award us, they're going to grant us an order in our favor. Now, that did not happen. And therefore, Attorney Barnes, that you're referring to, I think he is saying she's siding with the authorities and with the Democrat governor. I think that's not the case here. The issue here is the case was just a botched attempt. It's a wrong strategy. What they could have done is, if they indeed were stopped from indulging in their speech and others were allowed to do it at the same time by the local municipal police force, they could have sued them in district court for violation or discrimination based on their First Amendment rights and other sections or articles of the Constitution, equal protection of law and everything, and then taken an appeal. It would have been a better strategy to win the case. What has happened is a lot of people are putting a target on Amy Coney Barrett's back in this case. And I feel you're trying to test her, but you're expecting her to legislate from the bench. I'm trying to understand this. When you want a conservative judge, I thought the agreement is we do not want activist judges. We do not want judges legislating from the bench. And I think she passes that test here. Now, if you don't like the outcome, it's not necessarily the court's fault. It, in this case, to me as an attorney, it seems like the strategy was bad. It was just a wrong way to go about this. And secondly, if you want her to legislate from the bench, then you shouldn't be calling her a conservative judge. Then you're expecting something. So this is just a wrong test to test her on. You've given her the wrong test. It's a different test. So you're testing her geography. She's giving you an answer for geography, but you're expecting an answer in mathematics. That's what's going on. And because you did not get an answer in mathematics, you are blaming her for not being a true mathematician. Yes, you may be right, but this is not the case to demonstrate that. So that's my take on this particular case. What are your thoughts?
Yeah, no, and the fact that the plaintiffs in the case, right, all the Republican
Yeah.
groups that they're referring to, right, the Illinois Republican Party, they could still win the case. This was about the injunction.
This was just about the injunction. Yes, that's right. So this has nothing to do with the main case at all. And for an injunction, then, now that you bring up an injunction, there are requirements to be granted an injunction. And what are those requirements? Some of the most important requirements are, one, you have to demonstrate a likely scenario that you're going to win the case on its merits on the main case. That's number one. Number two, you have to show that irreparable harm is going to take place if this injunction is not granted. Now, that second point, yeah, maybe an argument can be made that the elections are coming. Our speech is political speech. If we cannot indulge in political speech right now, then when? When will we be allowed, and how can we change the outcome of the elections? We are indulging in political speech in order to guarantee a certain outcome in the elections, or at least facilitate a certain outcome of the election. That is to say, we want our party to win. And if we are not allowed to talk right now, are we going to have any effect after the election? No. But you know what? Surprise, surprise, right. They do not even make that contention. They don't raise these points. And even if they raise it, it's like a one sentence. There's nothing. I didn't see any of that. Then they're talking about, then they're talking about the balance. Then the third requirement is balance of equities, that the equities will be in your favor. That is fairness and all that. Now, those have to be balanced against the pandemic, the say, and so on and so forth. And the last one is this in public interest? Now, public interest, they'll have to show by us going out like this, and in the backdrop of the pandemic, COVID-19 going on, this will not have any adverse effect on the public safety, because the governor is saying, I'm doing this to make sure or ensure the safety of the public. So that point also has to be demonstrated. None of these points for the injunction have been really fought properly here. I don't see anything here. They just come out and go off on a tangent under the First Amendment. Just because, now let me tell you this, just because your case is about speech necessarily does not mean that the injunction is going to only be limited to speech. The injunction requires more things, because you are asking the court to kind of grant an order in your favor without even listening to the entire case. You're not talking about the merits of the case. So, in a way, you're asking the court to quickly jump in. And in fact, in this case, the court did jump in quickly, because they went all the way to Kavanaugh.
It was quickly.
Yeah. So from district court, they went to Kavanaugh to get an injunction, right? Because Justice Kavanaugh is responsible for the Seventh Circuit. He ignored it. Ignored it as in he didn't like just look away or something. What it means is legally he ignored it. He didn't take any action. He just sent it back. This court quickly took this case to hear the topic of injunction, not on the merits.
Right. That's an important point if you're using this to kind of judge Barrett,
right? You're judging Barrett. Now, if you go the other way around, that you went to court, this case, the entire case played out on the merits, and you lost the case, and then you went in front of Barrett and say, hey, by the way, our First Amendment rights have been affected. Please look into this and please analyze this completely. And by the way, the other protesters, they were allowed to do whatever they wanted. Now, that would be a different case. That case is not before this judge. The case is not before even the main judge, the district court judge. The case is still going on. What they try to do is get an injunction to kind of get what they wanted before finishing the case. And this court, including Amy Coney Barrett, ruled only on the injunction, and these guys gave them no ammunition regarding the injunction. Nothing. Just a.
Did you already make the point that also with an injunction, in order for an injunction to be granted, it needs to be like very likely that you would win the case?
Yes, I said that. Yes, yeah. You have to demonstrate that you likely win the case as well. So that's the issue here. They have done none of this. Not a well-pled case. You have to. The pleadings are important. The pleadings are important. You got to do a good job there. So, like I said, this is not the right test to test her on. If somebody has a different view, sure, we welcome it, but definitely not in my book.
Yeah, no. Yeah, good points, right? And the fact that it's an injunction case, maybe they'll still win. That's not what's being decided here.
Now, see, when you say about likelihood of winning, it doesn't mean that 50-50 chance or just a probability of winning. You got to demonstrate a strong case that because this happened, all these things have happened, and these are the facts in our favor. No matter how you cut the cake, we are still going to get the win here. So you have to show to the judge that, hey, judge, and I'll tell you why it's important. The reason is the injunction really is a decision. It kind of grants you a decision, a status quo in a case. It's not a stay. It's different from a stay. A stay basically stops the case itself. An injunction gives you an order. It kind of gives you an outcome before the main outcome. So if you want an outcome before the main outcome, what would you have to show to the court? What you would have to show to the court is, hey, the outcome is going to be exactly the same. It's hugely possible that we are going to get to the same. We're going to be back to square one. So right now, we're just asking you to put us in square one because why? We're going to win anyways. But if we wait till we win anyways, there's going to be irreparable harm. You see the point now? Yeah.
Yep.
So they're saying we are just wasting our time. We're going to win. It's like this. There's a bet between Governor Pritzker and the Illinois Republican Party that the sky is blue or red. Illinois party is saying sky is blue. Governor saying no, it's red. Illinois party has to tell the judge, hey, listen, the sky is blue. Here's the proof. Here's the possibility. And what is the logic? No proof, sorry. Here are the possibilities. The sky is blue because of sunlight coming onto the earth. Earth's covered mostly by water, and water reflects selectively. This is the wavelength. And guess what? By deduction, I think it's going to be blue, ma'am. So Judge Barrett, please can you just tell us, yes, it's blue. You got it temporarily. And we know we're going to. And Judge, if you don't say it's blue, guess what? We have an issue here. We're trying to teach our children. And the children have a test. Okay? Tomorrow, if we don't give them the right answer, that test they're going to fail the test. Irreparable harm. There you go. So this is how you have to plead the case. These guys did none of that. They didn't even attempt to do any of this. It was almost a guarantee that we have Republicans, we are Republicans. The opponent is Democrat. Guess what? Republicans and Republicans will come together like brothers in arms and we'll get a decision. When you don't get such a decision, then you're going to blame these Republicans and say, you're not conservative enough. And I think that's a wrong point here. I think they were being conservative. They stuck to what the statute and laws and precedent said, and that's exactly what you have to do. And Supreme Court cases, if there's some other Supreme Court case that you could have cited, you should have cited that. But I think they're failing to do that. Therefore, Attorney Barnes, I don't know what his review of this case and why he concluded that Amy Coney Barrett is not the right conservative. I don't know why he concluded that, but if he concluded using this case, that's the wrong case. You're barking up the wrong tree. I'm not saying he's wrong. He may have his own reasons, right? But this is the wrong tree to bark up.
Okay, yeah. So that's the Pritzker case that Barnes says that, characterizes Barrett as, siding on the side of authoritarianism and lockdowns. But there's some other cases, right?
There's another case which surprisingly he leaves out. And that's why I want to bring that in, because I think that case is a contrast. If you really want to measure her, I'm trying to give her a good test. What's a good test? Traditionally, conservative people would like to, put somebody through is a case regarding Second Amendment, right? Mm-hmm. Second Amendment. So this case is, again, the United States Court of Appeals for the Seventh Circuit. The case name is Ricky Cantor v. William Barr. Barr is the Attorney General of the United States. Quickly for people who are probably not aware, for those who are not aware of the facts, there are three judges: Flom, Ripple, and Barrett. Background of the judges: Flom and Ripple are Republican judges. They were appointed by Reagan. Barrett is a Republican appointed judge. When I say Republican judge, it doesn't mean the judge, you know what I mean. I mean
Yeah, how they were
appointed by
appointed.
a Republican
Right, by president.
president. So Flom and
Right.
Ripple are Reagan appointees, and Barrett is a Trump appointee. Now, in this case, Barrett is dissenting. That means she does not agree with the majority. It's a three-judge panel, and the two judges, Flom and Ripple, um, grant, you know, uh, an order on the side of the government, William P. Barr. And Amy Coney Barrett sides with the plaintiff, Ricky Cantor, who is a citizen. These are the facts. Ricky Cantor pleaded guilty to one count of mail fraud under 18 USC 1341. It's mail fraud under federal statute. It's a felony conviction. He pled guilty, okay? And he's prohibited from possessing a firearm under both federal and Wisconsin law, okay? Then even if Cantor could bring an as-applied challenge, the majority says the government has met its burden of establishing that the felon dispossession statutes are substantially related to an important government interest. We therefore affirm the district court. So he basically went to district court, lost. District court said, "You're a felon. You cannot possess guns." He appeals to the Court of Appeals, Seventh Circuit, and he loses there as well. But that's not the case here, right? We are not discussing really the case only. We are also discussing how Barrett might rule on conservative issues, so-called conservative issues, constitutional issues, because this is federal jurisdiction. So they go into saying, looking at all the case law, felons basically cannot possess guns. This is the majority decision. They go into the full analysis. They cite multiple cases uh, from so many federal circuits, including their own circuit, the Seventh Circuit. And they say on May 24, 2011, Cantor pleaded guilty to one count of mail fraud based on a shipment. Now, pay attention to what the charge is, because most people by now have jumped the gun, pardon the pun, have jumped the gun and concluded he's a felon. Why should he have a gun? Now, aren't you interested in knowing what the felony is about? So let's go into the
Yes, we
yeah.
are.
So let's go into the case facts. He has pled guilty to one count of mail fraud based on a shipment of the non-compliant inserts in a podiatrist to a podiatrist in Florida. It carries a maximum penalty of 20 years in prison and a $250,000 fine. He was sentenced to 1 year and 1 day in prison. So literally 1 day over the year, making it a felony, and 2 years, well, not making it a felony, but in traditional terms, understanding anything punishable for more than 1 year is a felony. And that's what these statutes say. If somebody's punished by a felony, or convicted of a felony, or convicted of a crime where the imprisonment was more than a year, then he cannot bear any arms. And 2 years of supervised release. So he has served his time and paid his criminal penalty, and he has not been charged with any additional criminal activity. So what did he do? What he did is he was making shoe inserts. So these are little wedges of foam which were put in shoes. His shoe inserts were too thin, so they were not covered under Medicare. So then he made thicker shoe inserts made of foam, sent it to Medicare, and Medicare said, "Okay, these are approved." Then what does he do? He starts selling the slightly larger inserts, which are approved, and also ships some of the old, thinner inserts. So this entire case is about foam, sponge, right? Foam inserts that you put in under your heel or whatever in your shoes. And that's the
Mhm.
felony. The felony concerns foam inserts, nothing to do with any
But the
violence. It's a non-violent
but
felony. That's what I'm trying to demonstrate here.
right, okay,
Mm.
right. So but he was the felony is what, Medicare fraud, basically,
No,
like
they
defrauding.
not even
No.
Medicare fraud, mail fraud. That he used the mail system to mail something from one place to another. He shipped it from Illinois to Florida.
But what was illegal about that?
Well, using the mail system to commit another fraud, fraud is
That's what they got. That's what
exactly,
he pled guilty to. The
exactly.
lesser crime, probably,
Yes.
right?
So they got him
Yeah.
on a felony. They got him on mail fraud. So there was no violent felony. He did not hit anybody with a shoe insert or even a shoe. There is no violence with shoes. None of that happened. So they go into Heller decision saying, the court identified the core of the Second Amendment as a right of law-abiding, responsible citizens to use arms in defense of hearth and home. Accordingly, the court concluded that Washington, D.C.'s ban on handgun, whatever, the Heller decision, where it says handgun complete ban is illegal, unconstitutional. So they go into this whole analysis, and finally, what they say is, listen, we're not going to get into the inquiry what kind of felony it was. We're simply going to blanket agree with the government, okay, authoritarianism. We're going to agree with the government and say, you are right, government. He's a felon. We don't care what felony it was, whether it was shoe inserts, form inserts, or mail fraud. We don't care about that. We're just going to say he cannot have any firearms for life. He's barred. Now, this is where the case gets interesting. He loses the appeal based on those two judges, but Amy Coney Barrett dissents. She says, no, no, no. I cannot affirm the decision of the lower court, that is the district court. Barrett, circuit court, dissenting. And she starts off pretty well. She says, history is consistent with common sense. That's a very nice opening statement, right? Common sense. People hate common sense when it applies to gun rights, but she even goes that far and she says, common sense. It demonstrates that legislatures have the power to prohibit dangerous people from possessing guns. Okay? But that power extends only to people who are dangerous. And that's where she starts beating down on this decision. She says, founding era legislatures did not strip felons of the right to bear arms simply because of their status as felons. Because there is no word, there's no felony in the Second Amendment. The Second Amendment does not use the word except felons. It does not say that. So what she's saying is the legislatures did not strip felons of the right just because they were felons, nor have the parties introduced any evidence that founding era legislatures impose virtue-based restrictions on the right. Virtue-based restrictions, let me explain. So what it means is if you're not a virtuous person, I mean, yeah, I know, some people think they're virtuous, but yeah. So if you're not virtuous, you cannot indulge in civic activities like being on a jury, voting rights, and stuff like that. So that's called virtuous. But there's a difference. Gun rights, under the Second Amendment, recognized rights, they do not fall under civic rights. These are individual rights. For example, the Fourth Amendment, right, and the Fifth Amendment. So any personal rights such as right to privacy from illegal searches and seizures, even criminals have those. You may have 10 felonies and your Fourth Amendment right and your Fifth Amendment rights are still intact, correct? Nobody argues about that, right? It doesn't matter.
Right.
You still cannot have illegal searches and seizures. Just because you know the guy is a felon, if he's driving a car, you cannot just go and stop him. Hey, I know you're a felon. What are you carrying this time? No, sir, you cannot do it. It's called an individual liberty. And this is important to understand. And that's why I want to demonstrate. The court doesn't, Amy Coney Barrett does not go into talking about those amendments, but I'm just trying to explain what an individual liberty is, right? Individual rights. So the Second Amendment does not fall in the civic liberties about virtues. It falls under individual liberties. Okay, so therefore, she goes on to say that the parties, that is, none of the parties, have introduced any evidence that founding era legislators imposed virtue-based restrictions on the right. Such restrictions apply to civic rights like voting and jury service, not individual rights like the right to possess a gun. And this is about history. In 1791 and and for well more than a century afterwards, legislatures disqualified categories of people from the right to bear arms only when they judged that doing so was necessary to protect the public safety. There you go. This is her case. She talks about what this is an individual right. She also talks about the founders did not ban felons just because they were felons, but they banned them because if they were dangerous. Okay,
Hey,
are
buddy.
we back? Okay.
Yeah,
So
we're
we had
back.
some technical difficulties, but I was talking about the Cantor v. Barr case, the Second Amendment case on which Amy Coney Barrett was the dissenting judge. So she goes into the history of the Second Amendment and the legislatures at that time. And what she raises are I think three keywords here: dangerous as applied to people, dangerous people, okay? This being an individual right, not a virtue-based civic right. And number three, public safety. So she goes into the analysis as to how each of these points do not make any sense in his case. She says, in my view, the latter is a better way to approach the problem. It is one thing to say that certain weapons or activities fall outside the scope of the Second Amendment. Okay, the sort of weapons protected were those in common use at the time. So common use doctrine was talked about in Hello. She says that's one thing, but it is another thing to say that certain people fall outside the amendment scope.
Hmm.
Arms and activities would always be in or out, but a person could be in one day and out the next the moment he was convicted of a violent crime or suffered the onset of medical illness. His right would be stripped as a self-executing consequence of his new status. No state action would be required. So she says, to be sure, under this theory, such a person could possess a gun as a matter of legislative grace, but he would lack standing to assert constitutional claims that other citizens could assert. So she's trying to discern or differentiate between what is constitutionally allowed and what a state may allow. In fact, she's saying a certain state might even say, hey, even in our state, even felonies can have guns. And then the person can possess a gun in spite of his felony. Okay, just hear me out. However, she's saying that felon, if he's a dangerous person, a violent felon, if the state then takes away his right, cannot come around and say, well, it's my Second Amendment right. No, because he lost that status as soon as he became a violent felon. The Constitution does not grant those rights, or the rights that are recognized by the Constitution, the Second Amendment. Those rights extinguish once you are a violent felon. This doesn't even need the operation by the state. It's automatic. But because that is automatic, she says, the automatic extinguishing of a right under the second, recognized under the Second Amendment, that automatic extinguishing does not happen if the person is a non-violent felon. That's not automatic. For that, then there is an added burden on the government. And what would that be? That would be to show that this person has the proclivity to commit any violence on people. And having him having possession of a firearm would be detrimental to the safety of the public. In this particular case, she says, Cantor was convicted of a mail fraud based on shoe inserts, foam inserts. There is no history of this man being violent. There is no showing by the government that he shows violent tendencies or in future he's going to become a violent person or he has any mental illness. None of that is shown here, and therefore she goes on into um, the history and all that. And she also talks about this. Heller did not undertake an exhaustive historical analysis or the full scope of the Second Amendment, but it did offer a list of presumptively lawful regulatory measures, including long-standing prohibitions on the possession of firearms by felons and the mentally ill. Like the majority, I am reluctant to place more weight on these passing references than the court itself did. So she goes into the analysis of even Heller. She says Heller did talk about this, but that was not the crux of Heller. Heller had nothing, we don't want to read more into what Heller was um, into, just like some passing statements that were in the Heller decision. So she talks about the history, the 3 points that I raised, and um, I think somewhere she also gives examples where people in the past could have been convicted of felonies for even silly things. Like today, those things wouldn't even be crimes. So just the felony doesn't mean anything. It has to be a violent felony or proclivity to violence and so on and so forth. So that's her case. Uh,
Hmm.
and
And you said
the
that's not one of the cases that
that's
that
not one of the
Barnes
cases
brought up.
that Barnes cites or investigates into, or you know, I don't think he's discussed this case, at least definitely not to the length we are discussing. And yeah,
Yeah, that's an important one. That's very
and
interesting.
and yeah, and to contrast it now, so if you want to put a target on her back, this would be a good test because it does test her mettle as a conservative judge and as a judge who respects and recognizes the rights recognized by the Constitution, the individual rights and civic rights, her understanding of these rights. And in fact, she even goes so far as to side with a convicted felon, a criminal. And she says if the Second Amendment was subject to a virtue limitation, there would be no need for the government to produce or for the court to assess evidence that non-violent felons have a propensity for dangerous behavior. But Heller forecloses the civil right argument on which a virtue limitation depends. So that means she is clarifying this is not a civic right, it's an individual right.
Yeah,
Mhm.
that's
And while both Wisconsin and the United States have an unquestionably strong interest in protecting the public from gun violence, they have failed to show by either logic or data that disarming canter substantially advances that interest. And I think she has very beautifully stated her stance and see why this case is difficult. This case is easy, actually, right? This should have been easy for her to simply side with two of her Reagan appointee Republican judges,
right.
but she
Long-standing
does not.
precedent. Right. That's
Correct.
right.
She doesn't go with that.
She's very creative, right? About
She's
some
very
would
creative,
even
and yes, and she also she uses the freedom that the Supreme Court has given, and why
hmm
there is freedom to these judges if they really want to clarify the Second Amendment, because the Supreme Court, um, and I don't know why, has not taken Second Amendment cases as frequently as any other
hmm
amendments. They just refuse. Even recently, literally a month ago, the Supreme Court was, not a month ago, 3 or 4 months ago, they had 10 cases before them and they were wondering which one to take. And everybody was excited. All the people who support the Second Amendment, they were excited. They said, we want them to take something because there are more Republican judges. Maybe they'll take the case and give us back our rights that have been infringed upon, right?
right.
They did not take one case, two cases, three cases, and they took 0 cases. So the Supreme Court is extremely reluctant to take those. Now, the logic is, it seems this is what is going on. Even though we think there's a 5-4 majority in terms of Republican appointed judges, like you said, like Barnes is saying, they cannot trust Roberts on Second Amendment. And he may side with the other judges who are anti-gun, and you would lose in Supreme Court. So that's why the 4 judges, the conservatives, then decided we don't want these cases, and they opposed taking these cases. So that's the grapevine. I don't know the truth.
Right, right.
But in this case, again, to contrast from the previous case, if you put a target on her back and say, we are going to test you, this is a good test to see what she says about an issue that is dear to conservatives, people who respect the Constitution, and how does she rule on this? And she actually dissents with fellow Republican judges and sides with the criminal and says no. And she goes into thorough analysis. Her dissent is 3 times as long as the main decision. She goes into history of the founders, then the legislative history at that time, into all the Supreme Court decisions, his history, that is the defendant, Mr. Cantor's history, plaintiff, sorry, in this case, the criminal history, and what the government's interest is to protect people, and she goes through every step of that analysis in very thorough terms, and finally comes out and says, she says, on this record, holding that the ban is constitutional as applied to Cantor does not put the government through its paces. So she's holding the government responsible, but instead treats the Second Amendment as a second-class right, subject to an entirely different body of rules than the other Bill of Rights guarantees. I therefore dissent.
The decision also seems to show that she's willing to reform, where, in other words, reform precedent, reform the law, right? Where it makes sense to do
no,
so,
she's
right?
not reforming the law.
So
The decision
that
shows that she's willing to clarify the Second Amendment's scope.
that's what I mean. Yeah,
Right.
right. The long-standing precedent was the opinion of the majority judges, right? She dissented from that, and
Correct.
seems to show that her take in this case at least was that of an originalist, right?
Oh,
Wasn't
absolutely.
Scalia really well
Absolutely.
known for that type of approach?
Absolutely. Absolutely. In fact, the Second Amendment, basically, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Shall not be infringed. It's a mandate. So in that, it is so straightforward. And she says, if it's an enumerated individual right, and in order for the government to infringe upon that right, they will have to be they'll have to work hard for this.
Yeah, that's an interesting argument. Yep.
Right.
Yep.
She says she uses this language. Look at what she says. She says, where's that decision? Give me 1 second. Let me pull up that decision again, because I don't want to put my words there, right? Let's see what her words are.
Yeah.
So we can put the target on her back. She says, on this right, holding that the ban is constitutional as applied to Cantor does not put the government through its paces. She wants the government to be put through its paces. What it means is, this right is so important, just like any other individual rights in the Bill of Rights, but you treat the other rights pretty well, and this one is some kind of a second-class right. She even uses the word second-class right. You got to put the government through its paces. The burden is extremely high to overcome, and the government must show that they have overcome that burden. And I think there she demonstrates bravery. She's a brand new justice. The other judges, in fact, let me give you some more trivia, right? One of the judges, a Reagan appointee, is the longest serving federal judge in the country.
Interesting.
He's like an old guy in the yeah, in the you know, he in the gun community they call some people FUDs. I don't know if you've heard of this term, FUDs.
No.
Yeah,
Buds?
yeah, FUDs, like Elmer Fudd. Okay, they call them FUDs, who they don't care really. They say, yeah, I've got a shotgun to hunt, right? Like what's his name? Joe Biden says, yeah, if you have an intruder, what you do is you point the shotgun up in the sky and shoot 2 rounds. If you ask any person in gun safety, no, you never want to do it. You want to know who's upstairs, firstly, and you cannot just shoot like that. That's not gun safety. That's just bad, very bad advice. And if you have a double barrel shotgun and you shot those 2 shots, now you have no shots left in there. And then you have an intruder and you're hoping the intruder just walks away. I don't get it. So anyway, so those are FUDs, right? So she is against, I'm not calling these judges FUDs, but I'm just saying it as a joke. But anyways, these guys are long-standing judges. They've been there.
And that all that matters, right? These are
All that
her
matters
colleagues.
because,
Yeah.
yes, all that matters. Okay, let me tell you how these decisions actually take place. When they hear the cases, they conference, they face each other, they exchange notes, they discuss why they are ruling a certain way. You know why? Because you need a majority. So they discuss that. Those 2 judges were able to convince each other. They were not able to convince Amy Coney Barrett. On the other side, she was unable to convince them. So that's why you had 2 on one side and she was on one side. But she did not allow herself to get convinced and just join them just because there was going to be an outcome. She said, I cannot do that in spite of my wish to agree with you and try to have a cohesive, good decision, a unanimous decision, because these courts of appeals, they create policy forever for the lower courts. So they do want to come together and issue a decision which makes sense. So anytime there is a dissent, remember that judge feels really, really strongly about his or her position. And Coney Barrett's position right now on the Second Amendment is pretty clear here, and I fail to understand why Mr. Barnes did not pick up this case to analyze and call her a fake conservative. Which again, I'm saying he may be right, but I am not seeing the cases. The cases he's citing do not show me that.
Yeah, that's very interesting. That's an important case. A lot of insights there into a,
Yeah,
especially a potential Supreme Court justice.
right, right.
So were there
And she has not gone against any precedent. She's not overruled any Supreme Court cases here. In fact, she uses those cases and she even says the Supreme Court never went into this. And she's right. The Supreme Court was extremely reluctant to talk about anything else. And I don't blame the Supreme Court completely on that either, because the issue was narrow at that time. The issue was narrow in Heller. DC, District of Columbia, had de facto banned all handguns. They had, but they were never issuing any permits. So in reality, nobody was getting any permits. So they had tacitly banned all handgun possession. So they took up the case and they answered that. Hey, yeah, people have is there an individual right to bear arms? And in the Heller decision, they said, yes, you have the right to protect your home and hearth. That is yourself, individual safety. And therefore, by doing this, a blanket, you know, kind of sleazy ban, that's unconstitutional. You cannot do that. And this is what distinguishes America, the United States of America, from all other countries, right? You have a Bill of Rights here. You have all these individual rights, and there's the First Amendment, then there's the Second Amendment, then third, fourth, fifth, all these individual rights, and uh, it's unique. And I don't know why the reluctance to rule on this. I know why the reluctance, because nobody wants to touch guns, because it's a difficult topic. But just because it's a difficult topic doesn't mean you can't touch it, because the Supreme Court did touch pornography. That is legal. It is protected speech.
Well, right. That's what they're there
um,
for, to decide on the
exactly,
difficult
to make the
questions,
hard. I mean, exactly. If the decisions were easy to make, and if we could trust everybody to make the easy and quick decisions, we would not need them. They have a specific job, not to legislate, because the legislators are legislating. But most of the time, a lot of states have been legislating like this. Now, William Barr, the Attorney General, could have come out and say, yeah, you know what? Another thing I forgot about that case, by the way. William Barr also says, by the way, the individual can make an application to us on a case by case basis to have his rights restored. So they make that argument. So therefore, you don't need to rule on this in his favor. But then the reality is, none of these applications have been granted because of a lack of funding. And Amy Coney Barrett says that funding issue and whatever issue and office issues that you have, it's not my problem. And it's not, much less Mr. Cantor's problem. So that's not going to fly either. So you can't trust these executives and the legislators to do the right thing. So then what do? Then you go to the court. But the court also, we expect them to practice restraint and not legislate. Don't create a new law just to cure a problem. So what do we want? What do we want them to do? Go to the Constitution, look in there, and clarify. Yes, no, this is unconstitutional. I don't need to legislate. Look at this. The Constitution is a rule book. This is what I like to tell people in simple terms. The Constitution is a rule book, and it applies to all games. The games may change, the players may change, the rules are the same. We don't want judges to create or change rules. The rules are created and changed by the people, and the people send their representatives. We call them legislators, the senators and the representatives of Congress. They are supposed to change the rules themselves. The judges are supposed to read the rules, understand the rules, and apply the rules. Simple as that. If somebody breaks the rules, the executive is supposed to go out, arrest the person, or whatever, take action against the person and say, hey, you have broken the rules. That's what we think. And then the redress is to go to court and decide whether they have indeed broken the rules or not. But generally speaking, people understand that concept. They say, oh yeah, there's a law, we go to court, and we decide whether the law was broken or not. There people seem to understand, but suddenly when it comes to these higher level judges, they suddenly want the judges to actually start creating the law, not applying the law.
Yeah, it's regardless of being a Second Amendment case, it's an interesting way to approach the
Correct.
Bill of Rights,
Correct.
individual rights, things like that. Like imagine they're not
Yes.
talking about gun rights, they're talking about, like you said, First Amendment rights, right, or whatever it may be.
Right. Or
Yeah,
stop and frisk, or
it's
yeah, exactly. Yeah. Or a vehicle
yeah,
stop. Somebody got stopped. Is there probable cause? Is there reasonable suspicion to stop the
hmm
person, and then probable
yeah.
cause?
I think people can appreciate. I think
Yeah.
anyone can appreciate that kind of approach to that stuff. Yeah,
Yeah. Yeah. And I think the Supreme Court has got many things wrong, and you need people to take a fresh look at the rule book, not at the law
right.
book. The judges are not there to create laws, because when judges sit and create laws, then you have two chambers of legislatures. We don't want two chambers of legislators. We have the legislators. And let me also go into the issue there that I have with legislating from the bench. When you legislate from the bench, what you're doing is you're taking away the blame from the legislators. The legislators created a bad law, okay? And you're writing that law, and those legislators go free, scot-free. The people who voted them into power don't, they have no incentive or motivation to vote them out of power or vote their opponents into power, because you just somebody keeps making mistakes, the other person keeps cleaning it, so there's never a problem. There's complacency. We need to allow every branch of government to perform its own duties. For example, when there is police brutality, right? When you allege law enforcement committed brutalities or mistakes, you got to understand several things. It's not only the enforcement part of it, but the law part of it. If the legislators never created those laws to give those powers to law enforcement would not be able to do that. But today I see the protests, they're only against law enforcement, when the blame actually should lie with the legislators and also the judges who handle these cases.
Right.
The Breonna Taylor case, for example, if I may, this was a no-knock warrant. Number one, why do we still have no-knock warrants in our country? And why did that judge grant that kind of warrant? In that case, the police say, well, even though we had a no-knock warrant, we still knocked and we said our name. I wasn't there, I don't know. And witnesses make mistakes. What we have is a dead woman, a very young woman who was who's said to have been a nice person. She had a great job. She was a nurse technician, respectable profession. And I don't care about respectable profession. Who am I to judge anyways? Even if she wasn't, even if she didn't have a job, she was just loitering around the neighborhood. How does that give us a right to simply enter somebody's house and shoot them? Now, the judges have to think about this, and law enforcement, you put them in that position. You issue the warrant and say, you got to go do this. And then the police show up. Then her boyfriend, and they break open the door. They have to get in. They have to get in because there was a warrant. I'm surprised nobody is talking about these warrants issued by the judge. Who is the judge? We have the names of the officers. We have the name of the person who died, Breonna Taylor. We have the name of her boyfriend in the house who allegedly shot a bullet and shot a police officer in the leg. We have the names of the police officers who allegedly shot back in self-defense. We have the name of the attorney general who came out and said, yeah, we're not going to charge them with any homicide or anything like that, not even manslaughter or even negligent manslaughter, negligent homicide, none of that. We have names of everybody. We don't have names of the judges and the legislators who passed these laws, who allowed these laws in that state. Why not?
Yep, the source, right?
The source. And that's why I feel these protests, although required against the government to protest against them, these protests which the non-violent, peaceful protests,
they're misguided.
Are these going to yield?
Ignorance.
Yeah, they're misguided. What are they going to yield? They're going to yield, even if they yield everything they want and they abolish the police and all that, is that going to solve the problem? Somebody else is going to take the place of those police to enforce the laws that are on the books and the method of enforcement. Now, remember, people need to understand this. There is statutory criminal law and there's also procedural law. All these laws have been written by the states. These are not federal laws, the individual states. And then they are applied by the local legislators, mayors, the police departments. And then when the cases go to court, the judges decide based on those
Right.
laws.
Because of the
So put the blame where it belongs. In fact, put it everywhere it belongs. Don't, I'm not saying that you cannot blame the police officers. If my sister, my daughter, or my mother was shot by anybody, I would blame them. So let's not have, and from far away, we don't want to say, I support this side, I support that side. You don't know anything about which side and what side. How can you support any side? Like, I have friends in law enforcement, but they don't enter people's homes and shoot at them.
well, they do if
Where is the discretionary part? Where is discretion? No, I handle cases. I make a living defending people's
right.
individual
What I'm saying
rights.
is that,
And
right. I'm
right,
saying, friends, anyone who has friends who are, law enforcement, police officers, again, they're following those rules, like you said, that are made, and because of lazy or whatever else, local legislation, right? Legislators, the people who make the rules, the judges, right? No one takes a second thought to things like that, right? And then,
right. Oh,
you
dude,
know,
I know many legislators who don't flinch. They don't flinch before
right.
passing laws. I can tell you, even village courts, even village legislators, like the board of trustees on a village, they pass. Okay, I'll give you an example. I was recently at a village meeting where they were trying to pass a law which banned parking on sidewalks. I asked them two questions. One, have you had any violations? No, we haven't had any violations in 3 to 4 years. Okay. Actually, I asked them several questions. The next question I asked, are you aware there is a law under New York vehicle and traffic law that bars that you can issue a ticket on for parking on a sidewalk? No, we don't know that. I said, all right, this is the section. Check it out. So you're trying to create a law which already you're creating a law that already exists. So you're double regulating an activity by a citizen. The third question I asked was the most important question. And you would be shocked. You'll fall off your chair. So just hold on. I asked them, are there any sidewalks in the village? And the answer was no. There are no sidewalks.
But there will be.
So I told them, you're trying to solve a problem that does not
Yeah.
exist. And there you go. This is the problem legislators try to they create a problem in their minds and then they try to solve it on paper, and everybody's subject to these laws.
And so coming back to your point earlier about Barrett, right? Those types of laws need to be thrown back to the legislative branch to be able, to be
Correct.
fixed. Yeah.
Absolutely. Absolutely. Fix
Yeah.
them. Right now it's unconstitutional, but keep it narrow, keep it to the point, because if you try to fix the law, it's called legislating from the bench. You don't want that thing to happen. You can just rule it's unconstitutional. As to this point, you cannot do this. Go back to the drawing board. I'll give you another try. Go ahead. But do not change the law, because we already have a legislative body. And to do that is to allow the legislators to get out of their duties, and they're getting paid a pretty penny, including healthcare and everything. And they become very rich. They go in with a few $1,000s, tens of $1,000s, or sometimes a few $100,000, and they come out millionaires or billionaires. There's a reason for that. So they better do their job. If they're really fleecing the taxpayer anyways and making so much money, might as well at least do a good job. So that's my take on it. And that's my take on Amy Coney Barrett. I think she's restrained and she is fearless when it's required. Good combination. Like I said, I'm open to listening to what Attorney Barnes has to say, but I want him to show me the right cases and not just make conclusory Twitter tweets. Give me an analysis, a detailed analysis of the case.
Well, thanks again, Mr. Joshi. Those are all great points. Next time, we're going to go into the issues that everyone's been hearing about RBG's dying wish. So that's it for now. Thanks again.
Yep. Thank you.